The Supreme Court just dropped a bombshell that will determine whether your concealed carry permit is a real right or just a worthless piece of paper. Legal ground is shifting right now, and what happens next will affect how 65 million Americans exercise their Second Amendment rights in grocery stores, shopping malls, and restaurants. 5 states have declared war on your ability to carry firearms anywhere that matters, and they think they found the perfect loophole to make Bruen meaningless. The Supreme Court is about to decide if they're right. If you want to stay on the front lines of this fight, hit that subscribe button right now, because every gun owner in America needs to know what's coming. The legal earthquake that just hit the Supreme Court just agreed to hear Woolford versus Lopez, and this is a direct attack on whether the right to carry firearms means anything in the real world. 3 Maui residents challenged a Hawaii law that makes it a crime to carry a concealed firearm onto any private property open to the public, unless you get explicit permission from the owner. Every store, restaurant, and mall is presumed off-limits unless someone posts a sign or gives written authorization. The Ninth Circuit said it's constitutional. The Second Circuit struck down New York's identical law as unconstitutional. Same question, opposite answers, total chaos. When federal courts cannot agree on what the Constitution means, the Supreme Court draws a hard line. That line is about to reshape every Second Amendment case moving forward. The coordinated attack on Bruen, after Bruen recognized the right to carry firearms in public for self-defense. Anti-gun states launched a coordinated counterattack. Hawaii, California, Maryland, New Jersey, and New York all passed sensitive places laws designed to nullify Bruen. Hawaii's version became known as the vampire rule, based on folklore that vampires cannot enter without invitation. The state applied that concept to your gun rights. You cannot carry onto private property open to the public unless the owner invites you through written authorization, verbal permission, or posted signage. Here's the problem. Most business owners never post any signage about firearms. Under traditional property rights, that silence meant you were free to enter with your firearm. But Hawaii weaponized that silence and turned it into a presumptive ban. Now silence means you're banned. No sign means no guns. Licensed carriers face criminal penalties for doing what the Supreme Court said they have a constitutional right to do. This was not an accident. This was calculated strategy to make carry rights so impractical that gun owners would give up. The historical fraud behind the defense. The Ninth Circuit tried to justify Hawaii's law using historical precedents, but what they cited reveals how desperate the argument is. The court pointed to only 2 historical laws. The first was a 1771 New Jersey statute prohibiting armed trespassing during hunting season. That had nothing to do with carrying in commercial establishments. The second is truly disgraceful. The Ninth Circuit relied on an 1865 Louisiana law passed after the Civil War as part of the Black Codes, explicitly racist measures designed to keep freed slaves disarmed and subordinate. Using Jim Crow-era oppression to justify restricting gun rights in modern times is morally indefensible. When gun rights advocates asked the full Ninth Circuit to reconsider relying on a racist Black Code, the court refused. The Supreme Court made clear in Bruen that gun laws must be consistent with America's historical tradition, not cherry-picked outliers from different contexts. Hawaii cannot meet that standard. What your daily life looks like. Under this law. Under Hawaii's law, here's your day as a permit holder. Coffee shop? Banned unless there's a welcome sign. Supermarket? Banned. Pharmacy? Banned. Restaurant? Banned. Every private business is presumptively off-limits unless the owner posted signage or gave personal authorization. Most business owners never post any signage. They're just running businesses and avoiding political controversies. But Hawaii decided silence equals prohibition. If you carry anyway, you're committing a crime. The Trump administration's Solicitor General called this exactly what it is, a near-complete ban on public carry disguised as property rights. The Supreme Court said you have a constitutional right to carry for self-defense. But if you cannot carry in stores, malls, restaurants, or any private business, what's left? Your home and the sidewalk? That's not a meaningful right. That's a right existing only on paper. 65 million Americans in the crosshairs. Hawaii didn't act alone. After Bruen, 5 states with anti-gun majorities coordinated their response. Hawaii, California, Maryland, New Jersey, and New York all passed similar restrictions. Combined, these states represent over 65 million Americans, more than 1/5 of the entire population. Millions who obtained permits, passed background checks, and completed training now cannot carry anywhere that matters. State legislators made a calculated bet that the Supreme Court wouldn't intervene if they technically allowed permits while making them practically useless. Now, all 5 states watch with alarm because if Hawaii loses, their laws fall with it. If the court says states cannot flip the default presumption, then California's law is gone, Maryland's law is gone, New Jersey's law is gone, and New York's law is gone. All struck down by a single ruling. This is about whether states can engage in coordinated constitutional resistance. The ripple effect threatening every gun right. This case is bigger than where you can carry. The Supreme Court's reasoning will cascade into every pending Second Amendment challenge, and there are dozens moving through federal courts. States have tested boundaries. Some banned carry in parks and beaches. Others prohibited firearms on public transportation. Several restricted carry in establishments serving alcohol. The fundamental question is whether states can use location-based prohibitions to functionally eliminate the right Bruen recognized. If Hawaii wins, expect explosive expansion of banned locations nationwide. States will declare 90% of public spaces presumptively gun-free. If challengers win, existing restrictions could fall immediately, and states face real constitutional boundaries they cannot cross. This is not just one case. It's a trigger. The dominoes are lined up, and whichever way the Supreme Court rules determines whether they fall for gun rights or state control. The Ninth Circuit's pattern of defiance. The Ninth Circuit compiled a perfect record before Bruen. 50 challenges to gun laws, 50 decisions upholding restrictions, 50-0. A shutout revealing systematic refusal to recognize Second Amendment protections. When Bruen changed the legal framework, observers expected adjustment. That didn't happen. The circuit continued ruling against gun rights with identical regularity, dressing decisions in historical analysis while reaching predetermined conclusions. Judges within the Ninth Circuit have publicly called this out. One judge accused the majority of giving a judicial middle finger to the Supreme Court. The justices aren't just resolving a circuit split. They're correcting a court that won't faithfully apply constitutional precedent. By taking Woolford, the Supreme Court sends an unmistakable message that open defiance won't be tolerated. The Trump administration enters the fight. The Trump administration weighed in forcefully. The Department of Justice filed an amicus brief recognizing Hawaii's law as a direct threat to constitutional rights. Solicitor General D. John Sauer argued the Ninth Circuit's decision fundamentally conflicts with Bruen. Hawaii's law operates as a near-complete ban because most businesses never post signage. The brief warned about cascading effects. 5 states have similar restrictions. If Hawaii wins, others will copy the model, and carry rights become meaningless across the country. Administrations are usually cautious about state law disputes, but the Trump administration calculated that protecting constitutional rights from state nullification demands federal involvement. They're telling the Supreme Court this is about whether states can collectively undermine federal constitutional precedent. The case that redefines the future. What the Supreme Court decides will echo through Second Amendment litigation for decades. The case answers fundamental questions Bruen left open. Can states presume firearms banned unless explicitly welcomed? What qualifies as legitimate historical analog? Does the right to carry mean you can carry where people live their lives, or can states carve out so many exceptions that the right becomes empty promise? The decision creates binding precedent every federal court must follow. Lower court judges, sitting on dozens of challenges, are waiting for guidance. Major gun rights organizations filed briefs supporting challengers. Gun control organizations and state attorneys general filed briefs defending Hawaii. Oral arguments are scheduled for January, with decision expected in June or July. Those answers determine how Americans exercise Second Amendment rights for the next generation, and whether Bruen was real expansion of liberty or empty words. The line gets drawn here. The Supreme Court is about to decide whether the right to bear arms means anything beyond words in the Constitution. Woolford versus Lopez determines if your permit gives real protection or if it's just a worthless card. This affects 65 million Americans in 5 states, but precedent reaches every corner of this country. If Hawaii wins, expect nationwide rush of states copying their model. If challengers win, multiple state laws fall simultaneously, and clear constitutional boundaries get established states cannot cross. We're covering every development from oral arguments through final ruling. Subscribe so you don't miss updates. Hit that like button if you believe Hawaii's law violates the Second Amendment. Share this with every gun owner you know. And here's our question. If your state passed a law like Hawaii's, where you need explicit permission to carry in every store, restaurant, and business, would you even bother keeping your concealed carry permit? Or would the restriction make it pointless? Let us know in the comments. The Supreme Court is about to draw a hard line. Now, it's our job to make sure that line protects the rights the founders guaranteed. Conclusion. The Supreme Court is about to decide whether your concealed carry permit is real protection or just worthless paper. This affects 65 million Americans now, but the precedent reaches everywhere. If Hawaii wins, states nationwide will ban firearms from virtually all businesses. If challengers win, multiple state laws fall and clear constitutional boundaries get established. Subscribe so you don't miss updates, hit that like button if you think Hawaii's law violates the Second Amendment, and share this with every gun owner you know. Here's our question. If your state passed Hawaii's law requiring explicit permission to carry in every store and restaurant, would you even keep your permit, or would it be pointless? Let us know in the comments.